make no doubt about it, we as lawyers have a significant role to play in connection with the incident response team. And I'm heartened to hear, Sari's, comment that one of her first, requests of the client when she gets the call is to talk with the lawyer, get the lawyer involved for obviously the attorney-client privilege issue, as well as because, there's a legal role there that needs to be fulfilled. Looking at just across the U.S. states, most states, have adopted some kind of a data breach notification law or regulation. I think Trevor this morning was saying he thought the count was 45, 46. It's up around there. There are a handful of states that have not adopted, a data breach statute, but they're few. And I think in line with comments made by other speakers today, there is, a sense that we do have a national standard, if you will, developed through the states with respect to data breach. We find that companies will, try to adhere to the highest common denominator in terms of state data breach requirements. And the general rule, and of course I'm making a generalization here that does not apply in all states, is that the trigger for a notification obligation is the unauthorized acquisition, disclosure, access to the personal information. And in most states there's a harm standard that would apply as well. In other words, is there a risk of identity theft? Is there a risk of harm to the consumer as a result of that unauthorized access? There are some states, though, that require no such risk harm threshold to be met. It's a pure, simple, automatic, was there an unauthorized acquisition? Personal information across these various state laws is defined generally to include the person's name together with some other data elements such as the Social Security number, a bank account, or other account data element. There's really a vast number of different data elements when you look across all of these various data breach state statutes that can actually trigger a notification obligation. Someone mentioned earlier today, I can't remember which speaker it was, about having a summary of all, getting the summary of the 50 states or the 46 or 47 states data breach requirements and having that handy at the time of an incident so you can, be sure what the requirements are in each of the individual states depending upon the type of data that is breached and the resident status of the individual who is the subject of that data. Other key variations across the states, I think that the critical ones that I see in data breach incidents really revolve around the timing of the notice, how soon you need to respond. I think there is a tendency for most clients to want to, get the word out sooner rather than later. I think that's reflected somewhat in the cost statistics that Andrew pointed to, where the promptness, the speed with which you do your notification, and that tendency to want to get some notification out to your customers, that sometimes backfires and winds up costing you more ultimately in terms of having to deal with that data security incident. In some ways, one lesson might be to slow down, do your investigation, make sure you understand the facts, and then provide your notification. Now that's all well and good, but you still need to look at what the state notification requirement says about timing of the notice. For example, in California, if it's health information, health records that are compromised, under their state statute, you've got 5 days under that statute within which to notify the affected consumers. That's a very short period of time. Other states, have a more flexible standard, which says, as soon as reasonably possible, following an investigation, you have a duty to notify. So the timing of the notice is something to keep an eye out on with respect to looking at these obligations, and the content of the notice, what needs to be in the notice. There is a lot of uniformity with respect to the contents, but there's also some inconsistency. You have some states, like Massachusetts, that say, you're not permitted to disclose the nature of the incident. And that's contrary to most other state data breach notification requirements, which actually require you to say something about the specific nature of the incident. And then, of course, you have, because we live we're talking about U.S. law here, we have this issue of preemption and what happens when you have an overlay with respect to federal law in this area. So some of these state data breach notification statutes expressly provide that if you have a breach and you are subject to federal law requirements, either under HIPAA, GLBA, the Gramm-Leach-Bliley, or some other federal regime, then your compliance with that, with those laws, with respect to that breach, will satisfy your state law obligations.